Oh, goodness. I'm sure we have lots of questions today, and they're probably going to be some that I don't have all the answers to. I will be very adamant when I let you guys know LA has a moratorium that covers the entire county, no evictions until until the last day of this month. They covered the whole county. It's not individual cities anymore. The whole Governor Gruesome has stepped in and took over the whole county and is making decisions for the county and not letting the individual cities make their own moratorium. So the whole county says no evictions until after the last day of this month. I have an idea that that's going to get extended. So not sure, but you never know, you know? Anybody have anything that they want to chat about, talk about? Why is my phone beeping like my phone's doing weird things, you guys? Bear with me. I'm clicking all over the place. Okay. So please know that there's an eviction moratorium in all of LA County until the last day of this month. If we want to get an eviction in LA County, we have to do an emergency order through an ex parte hearing to get a judge to allow that to happen. So quite challenging in LA County right now, but line up your ducks because when it's time, we can go after them. Nope, you can't serve hold on, somebody's asking me about a 60-day notice. Technically, we can't terminate tenancy unless we have cause.
Okay. Now I have a couple of questions. I don't know how you're going to let people in. Do you have a procedure or no?
Let people in as far as what?
Asking a question. I mean, I don't know how you're taking
Sarita, go. You got.
Hi, Patty. Okay.
Me, baby, it's your turn.
I have a property in Beverly Hills, and of all my experience, they're the worst tenants ever. My question to you is, am I required to put in the lease the months that we heat the pool? Or in other words, I called the city of Beverly Hills. They said there's no code enforcement that requires us to heat it like between February and September. So do you think it's best to put it in a lease, the heating days, or not leave it not included in a lease?
Absolutely. Absolutely. I would put what months the pool will be heated if you're paying for it. If they're paying for it, who cares? Okay.
No, they're not paying. Okay, I'm not. So it's better to put the months of heating in a lease. Is that you're saying? Absolutely, that's good, right?
Right, because you're telling them what the rules are. So
right,
let's say if you don't put that in there and they want to use the pool in, I'm just talking out loud, January, you're going to have to heat it.
Got it. I got
it. So put that in your rules as your pool rules of when that's going to be heated.
Right. Next question. Confidentiality. Right now, I'm leasing a lot of properties at least 400 to 500 below the prior tenant. My question to you is, can I put in their lease to keep their rental amount? Can you still hear me? Because it went blank. Oh.
I can hear you.
Oh, I'm on a cell phone. Should I put a confidentiality of the terms of the agreement in the contract?
In regards to what?
That they don't talk to all the tenants and tell them the deal they got.
You can put that in there, but please heed my warning. If you're not treating all the tenants in the building the same, you could be dealing with a discriminatory action from fair housing. So as long as you have documentation to cover your butt as to why you gave those people a better deal than you gave those people, so it doesn't look like discrimination, you should be covered.
Well, I better do it then, because you're right. I won't do that, because the only ones I'm giving deals are people who are moving in now because of COVID and the price drop. The ones that aren't getting the deals, the ones that have lived there for 5 years. So you're okay. I'd rather not put it in there and not
Bingo.
Right. Okay. Yeah, then that was it. Those are the two questions. But the heating of the pool, I'm glad that's important. So thank you.
Yes.
Okay.
Definitely. Anybody else have a question for me?
This is Jackie.
Yeah, if you have a question.
Can you hear me?
Yes, Jackie.
Okay.
Yes, I can, Jackie.
Okay. I know that if we put in the lease that any conflicts with the landlord, the tenant, would be handled by arbitration.
Mhm.
Can we do that? Or no, that's against their civil
Oh, hold
rights.
on, hold
Okay.
on, hold on. Lots of questions in a quick minute. Technically, yes, you can say that they must go to arbitration, and arbitration court, our standard car issued forms, specializes and covers that area. Here becomes my question. You as a landlord have more protection under UD law than you do under arbitration. So just saying, you may want to go through the actual eviction process rather than arbitration court. Arbitration court is you two coming to an agreement. It's not you evicting and getting possession. So you can leave that in your contract, but you as the landlord have a right to determine which way it's going to go. And most likely your attorney is going to advise you to put it through landlord tenant court rather than arbitration.
But if it's a frivolous lawsuit, that could end up being very costly.
Let the courts deem it as being frivolous and let them throw it out.
That doesn't seem to be happening, but I hear you.
What are your concerns?
Just trying to nip in the bud with the tenant complaint problem. And I was the landlord that had a slip and fall on my property, and so I just want their attorney to be able to see that there isn't a case, that the tenant wasn't even supposed to be on the property. And this was a law firm, Jacoby and Myers. We know their billboards, but you know what?
Ambulance chasers. Yes,
Yeah.
I'm familiar with them.
So what did they do today? They called me and say, all you have to do is give us your insurance company name and we'll file the claim. I said, we're not giving you anything. We haven't even told us what the problem is. Hey, the tenant fell and broke her ankle. I had even mailed an acknowledgement of her vacating the premises because she broke up with her partner.
Okay. Okay. Hold on. Let me help put this in perspective for you. Anybody could slip and fall on your property at any time. I could go deliver a notice for you tomorrow, trip over a sprinkler, fall and break my leg. Nothing you put in your rental agreement is going to help you. What helps you is your coverage on your property as far as lawsuits go with your homeowner's policy. Okay? That's where your comfort zone is. If you get served a lawsuit, the very first thing you want to do is call your insurance company. If your insurance company says that they won't represent you in that particular lawsuit, that's when you want to have an attorney step in.
Okay.
So what I'm trying to explain to you is it could happen at any time, and that's what your homeowner's insurance is for.
Okay, so I just finished a 3-year lawsuit with jury trial, and we won 100%.
Yes,
but
do you know how excited I am for you that you won? But yeah, I get you.
That was a crappy 3 years, and we are smarter now, but I think early on the attorneys of the insurance company should have pushed back more aggressively because it was all BS.
I understand.
Okay.
I understand. And that would be for your homeowner's insurance for you to have a conversation with. They should have pushed, they should have this, they should have that. Did you end up having to pay for any of those legal expenses?
No.
You are very fortunate. Hit the button. I'm glad your insurance company worked for you.
So then I have this.
In other words,
yes.
Okay. There's not a whole lot you can do to protect yourself from that. And I'm going to be honest with you. When we get off this call today, you could go down to the courthouse today, right now, and file a lawsuit against me because you don't like the color of my hair. That doesn't mean that you're going to win just because you got filed a lawsuit, most likely the courts are going to deem it frivolous and it'll eventually get thrown out. But what you're trying to do is take away our civil right. In the event that we feel that we need to be sued, everyone is entitled to their fair day in court. Your particular tenant found out that there was no fair day in court for them because they didn't have a suit, and that's why you won. So I'd love to tell you that there's some magic words you could put in there to make that not ever happen again, but the reality is there isn't, unfortunately.
Okay, so here's my last question. There are hold harmless agreements, right?
Mm-hmm.
You could have a worker, handyman, sign that if he's going to work for you, hold harmless.
Right.
I would
And then
think,
can I explain something to you just so you understand? You can't hold harmless the liability until the liability happens. Okay. So if they fall and break their leg, that's when you get them to sign a release of liability and a hold harmless, not prior to.
okay.
You can't write off the liability and the hold harmless until the accident happens.
Okay, I was just thinking that if I put a hold harmless agreement in a new tenant landlord agreement,
Most
then
of
at
them
least
have a
they would
hold.
have the mindset that we have to work this out.
Yes, most of them have a hold harmless agreement in them already. Just so you know, it may not be easy for you to find because it's all written in legal terms. Yeah. So if you're using the CAR forms, California Apartment Association, or one of the apartment associations rental agreements, there is a hold harmless in there as part of their lease clause, but it's all written in legalities. So you may not see at what that is. Does that make sense?
Yes,
It
I'll
might
look
be
at
written
again.
in language you're not familiar with. How's that? Let me rephrase that.
Okay. I
So if
can
you're
check.
using a CAR form, if you're using an apartment association form for your rental agreement, it already has that hold harmless in there. It may not be written in terms you recognize, but it's in there.
Okay, so I'm going back to my slip and fall person,
Yeah.
ex-tenant. We just want to shut this off before we get our insurance company involved. I mean, we just got through with 3 years.
I understand. And the only way that you could completely shut that off so you have no exposure there is not to do any rentals.
Yeah, that's what my husband brought up to me this morning. Yeah.
I mean, you're asking me very direct questions and I'm trying to give you direct answers.
Yes.
Unfortunately, when you have an investment property income business, you are susceptible to frivolous lawsuits.
Okay.
End of conversation. It's that simple. I would love to tell you, I know the magic secret, but the reality is there isn't one.
Okay. Got
it. The only way that you can completely eliminate that potential liability is not to have the liability to begin with.
Okay.
Which isn't why I'm here. I want to help you manage your investment property and make them profitable for you. I don't want to tell you, sell your property and run for the hills, because that's not my intention. But it's just part of the business we got involved in when we decided we wanted investment property. There's a lot of things we signed up for nobody told us about. Frivolous lawsuits is one of them. Anybody else have a question?
Yes. Can I ask a question?
Yes, you can. Of course. That's why we do
Sorry,
this.
I've really screwed up. So anyway, I served a 60-day, so there's no more 60 days to be served unless there's a health and safety problem, right? So I served a 60-day year ago and I didn't follow through. So this time
Hold on. What city are you in?
LA City.
LA City.
Mayor garbage.
So in rent control, non-rent control.
2003, not under rent control. Built.
Okay, so you can terminate tenancy, but you have to have cause right now. So a 60-day would be, I'm permanently removing it from the rental market. I'm moving back in. Those would be causes that you could evict for in the city of LA right now and still be away with it. So it's our cause evictions. Let me give you 4 examples. I'm moving back in. I have a direct family member, either up the tree or down the tree. My children or my parents are moving back in. I'm selling the property and permanently removing it from the rental market. I have repairs that health and safety is involved in and have already pulled the permits because they're expensive repairs. These are all reasons that you could terminate tenancy now and have some teeth in it. But if you just want to take your house back or you don't like them, that's not going to fly.
Okay. I kind of screwed up. This is a long thing where the person she assaulted me a few years ago and I didn't do anything. And I was bloody. She's smoking pot and I don't know what else. And unfortunately, it's not.
Hold on. Let's talk about this. Did your rental agreement say no smoking?
No, I didn't have an agreement with her. I sort of inherited her. I screwed up. And I can't get rid of her. And she hasn't paid anything. It's not a legal unit. And I've already moved into the legal unit.
Whoa. Wait a minute. It's not a legal unit. You don't have a certificate of occupancy?
I've talked to you this before. I screwed up. It's a storeroom. And
Okay.
I didn't rent to her. And she was just the person who I evicted, he had rented to her. And she said she was just not going to live there and use it just as a
storage
practice room for music. It's I was going to make it into my office, but I've lived there off and on, but I permanently moved in there a couple years ago. Yeah, permanently, 100%. But I've always had, it used to be my family house a long time ago, but it was built in 2000.
If it's not a legal unit, it would be a 3-day quit.
Oh, really? Oh, everybody was telling me it was 60-day, 3-day quit. And I haven't received anything for 3.
As long as you're not accepting rent monies on there, you're most likely going to be able to do a 3-day notice to quit. I definitely call Fast Evict and talk to them. For this matter, you either want to talk to Fernando or Joel or Brandy.
I haven't, I did receive something maybe a few years ago. And, but then since 2017, I've received nothing, just a headache.
I got you. So I would call Fast Eviction Service and talk to either Brandy, Fernando, or Joel. Those are the 3 people off the top of my head that are more well-versed with LA City and illegal units than anybody else in the firm, other than the attorneys directly. Brandy, Fernando, or Joel.
Joel, okay.
I wouldn't talk to anybody else but those 3 people regarding that matter.
Oh, are you back there now?
I am.
Oh, okay. I thought I saw
something. I'm gonna go talk to one of them about that. You know what I mean? It's not my area. Everywhere else is, but I try really hard to keep up with LA. But it changes when the wind blows, so it's difficult.
3 days. Okay, I had these 60 days to quit, and then
because it's an illegal unit, you're more than likely going to be able to do a 3-day to quit. But you need to talk to Brandy, Joel, or Fernando.
Okay. When can people start serving notices? Not yet.
After the order to shelter in place is lifted, but it depends on what the notice is that you're serving. So it just depends. If you're dealing with something on a health and safety, a nuisance, things along those lines, you can do the eviction much faster than waiting on a 60-day. You can serve the notice now. It just depends on what you're doing, and it's going to be a case-by-case scenario, especially within LA County. But I'm telling everybody, until the order to shelter in place is lifted and the library is open, because that's a great example of everything's open. Now the library's open. So use the library as reference, okay? When the library opens, that's when we can start serving our notices to terminate tenancy. And we'll talk about when is the right time to go ahead and issue a notice of rent increase. We still haven't heard from Fair Housing yet, over what's a reasonable amount of time to increase rents after a global pandemic and it not be considered a retaliatory eviction. So very careful there. We aren't running to the masses. We're taking a slow step and approaching it gingerly. I don't want anybody to get sued. I don't want anybody to be stuck in a 3-year lawsuit. That's ludicrous, but it is what it is, unfortunately. So with that being said, I'm going to tell you to err on the side of caution. Definitely talk to the professionals that are going to be standing there next to you in court going to battle with you, but we don't want to raise rents right now, and we don't want to terminate tenancy without cause. We can't.
Because she won't let me in. And
She won't let you in?
And she disconnected. She's a drug addict.
Okay.
She disconnected all the smoke detectors.
Okay, listen to me. If someone doesn't let you in, hold on. If someone doesn't let you in a property and you're serving 24-hour notice, that's not only a violation of a rental agreement, that's a violation of the law. California Civil Code 1947 says that if an owner posts proper notice in a conspicuous place on the door at least 24 hours in advance, you must allow them in. So if they're not allowing you entry, you're more than likely going to be able to evict them now based on cause, not on money, for them not allowing you in there. You're welcome.
Thank you. Because
in other words, I'm feeding you the tools you need to let you know which road to go down. You're going to build a case on cause based on the fact that she won't allow you in.
Okay, I'll serve the
24-hour notice to enter. And if she doesn't allow you in, you call us, because then it's going to be a 3-day curable breach of covenant, followed by a new 24-hour notice to enter for necessary or agreed upon repairs, preventative maintenance inspection, check the smoke detectors. Those are all reasons that I would put on there. And then we're going to do a new 24-hour notice to expire on the 3rd day. If she still doesn't let you in on that 3rd day, you're more than likely going to be going to a 3-day quit and starting eviction within 6 days or so.
Holy cow. Okay, this first 24-hour notice, should I put this, check the smoke detector? I know
I
she
would
took
put
it down.
check the smoke detectors and preventative maintenance inspection. The reason I suggest that is that gets you into everywhere.
Okay. And then if she just ignores me, and I'm going to put it on the
if you
front door.
if you get there, or she calls you and says you can't come in, that's when you call us, because we're going to need to do a 3-day curable breach of covenant based on failure to allow entry, which is a violation of California Civil Code 1947.
Well, I know she's going to ignore me. I'm going to put it on her front door. Should I open her front door?
That's fine. Let her ignore you.
Oh, let her ignore me.
No, just
She's
take
gonna
it right
ignore
to
me.
the front door. I understand that, but by ignoring you, she's building the case for you to evict her right now. Let her ignore you. That's her fault, not yours.
Should I open the front door and throw it in her unit or no?
Tape it on the door.
Okay.
If you open the door and you didn't serve notice first, you're actually in violation of the law. So
I really don't want to go in there.
don't do that. Just post it on the door, take a picture.
Okay, I'll take a picture of that. And all these laws keep changing.
Yes, they do. And they're very difficult to keep up with. They're giving us new laws all the time. They're changing the process and procedure of how the courts are even going. I don't know if you guys know this, but the courts opened on October 5th. On October 7th, the Judicial Council changed the way we file an eviction. So they added a 4-page cover sheet that is insane with information. And now if it doesn't have that 4-page cover sheet, it gets kicked back and denied. So you got to start all over again. So we've been chasing our tail for a hot minute so far this month. Sorry, I'm getting calls. I'm trying to deny them. But we've been chasing our tail here at the law firm, trying to keep up with the Judicial Council and then changing the rules as we're going along. So it's challenging not only for you guys, but for your legal counsel as well. So hang in there, bear with us. Yeah, remember, we're not driving the bus right now. COVID-19 is driving the bus, okay? We are not in control.
So you are filing some lawsuits?
We are able to file evictions in LA County right now. We do have to go in with an emergency hearing in order to get permission to do an eviction. However, you can line up all your ducks to evict for cause. Failing to allow entry would be cause. Modifications to the property without written consent of the landlord could be considered cause. Just depends on a written agreement or not a written agreement.
Does it have to have happened within the last year?
It has, in LA, it has to happen within the last 30 days.
Oh, crap.
Anything over 30 days in LA, you waive.
Oh.
So let me give you an example in LA. Let's say somebody says, my dad's going to be staying with me for a couple weeks. Okay, a couple weeks turn into a couple months. You knew about it and you keep taking the rent. 6 months later, you want to tell him, hey, no, dad's got to go. By accepting the rent and not doing anything in the first 30 days, you waived it, and now that's okay. Welcome to LA. Okay, so in LA, you need to react fast. And it's so hard in the city of LA. If you're trying to manage your investment property part-time, please hear me, please. Hire a professional to do it for you, especially in LA, if you don't have the time to put in what it takes to manage that investment, because those tenants will steamroll you. Ed, are you still with us?
Yes, I am.
Ed handles that area. Introducing, just so that you guys know, Ed is a professional property management company. When Ed gets in trouble, guess who he calls? Hi. So just saying, I try to recommend people that utilize me or utilize fast eviction service for the simple fact of, at least I know when they have a problem, they're going to call me. I'm still kind of in the loop with what's going on with your property. So just a curveball I try to utilize is it keeps me in the loop, but also I know that I have a professional manager that I can call and talk to regarding your case. They're going to line up your ducks like a professional management company does, which makes it so much easier when your attorney gets into court because everything's together. You know, they speak the attorney's language. So Ed is putting a phone number down there at the bottom of the screen. Feel free to contact him. He does handle LA City, which is extremely challenging. Hoorah to you, because LA is no joke, you guys, no joke. Anybody else have a question for me? Thank you, Ed, for being our savior.
Thank you, Patty.
Okay, you can evict a tenant. No worries. Hey, it happens sometimes. Can you evict a tenant for not providing the homeowner insurance with? Yes, actually you can. Let me see who asked that question. Can you evict a tenant for not providing homeowner insurance per my lease in San Bernardino? I believe what you're speaking of is renter's insurance, not homeowner's insurance, just so that we're on the same page. Yes, David, I know. And if it's a term of your rental agreement, you can absolutely do something about it. The first thing you want to do is a 3-day curable breach of covenant. They're in violation of their written rental agreement by not having renter's insurance. If they don't fix that by providing you proof in 3 days, you're most likely going to be able to serve a 3-day notice to quit behind that and then start the eviction based on cause, not on money. See how that worked? If you're going to go those steps and you're going to actually go through and evict, it is my personal opinion, not legal advice, okay, that before you do all of that, you go into the property. When's the last time you did an interior inspection? Go in there and see what other changes are going on. Go see what other modifications that they've done without your permission. You and I both know the first thing we do when we buy a house and we're going to move into it is change the locks.
Well, not only that, you also want to check for habitability issues to make sure that everything.
Absolutely. Absolutely. But we also want to build not one violation, but several of them, so that if they cure one, then they got to cure them all. Okay. So I don't want to say you're setting them up for failure, but let's face it, right now, the legal system is quite challenging. A 12-gauge shotgun is much faster than going through the legal process, but we can't shoot people. Okay. It's not allowed in this country, but it is extremely faster. So with that being said, we want to line up all your ducks. We want to put everything we possibly can put on that covenant notice, that when it comes time for the attorney to start firing them off, you got plenty of ammunition behind you, okay? That's the meaning of that. So in other words, if you're going to evict right now on cause, try to see if there's more than one cause, because I'll give you an example. Let's say Ed rents one of my properties, okay? And I know he has unauthorized occupants and unauthorized pets. And I went in his property and I saw this long laundry list of everything he's done wrong. He's changed the locks. He has unauthorized pets. He has unauthorized people in there. And all I put on there was the unauthorized people and the unauthorized pets, because I felt that would have more teeth. Well, watch this. Now Ed gets to court and he says, but wait a minute. Those are unauthorized occupants. Those are my caregivers. I'm disabled. Boom, that's gone now. That's in the trash. Let's talk about unauthorized pets. Oh, those are my emotional support animals. Here's the documentation. Boom, that's gone. Now what? You're done. That's all you put on your notice. So you can only argue in court. I'm sorry, your attorney can only argue in court what's on your notices. So the more ammunition you have, the more chances you have for one of those to actually impact and come through. Can you do it on that term? Absolutely. But in my opinion, I would want more teeth in there, especially right now with COVID. Every about COVID and COVID protecting these tenants and all, you know, what about us? What's helping us? So I'm here to tell you, don't write down one violation, write down everything that you know they're doing wrong and see if that helps get you possession faster than shooting them off one at a time. Fair enough? I saw something else come through on the chat. Let me see what that is. Okay, we're good. All right. Anybody have any more questions? And again, I'm sorry for being late this morning. Okay, here, I got another one. Patty, I realized that I do not have a copy of the rental agreement on 3 of my apartment rentals. Is there no issues with tenants? There are no issues with the tenants. What should I do? You can, I'm assuming they're on a month-to-month at this point and not in a term. And at this point, you can ask them to re-sign a new month-to-month agreement with similar terms. In other words, you don't want to increase the rents or increase the late fee or do anything weird, but just new term for another 30 days should not be a problem. And if that doesn't work and they refuse to sign, call here at the law firm, because there is a little trick that we have on changing rental agreements with a 30-day notice of change of terms of tenancy and then the agreement becoming the change. Okay, so there's a trick there, but you have to go through process first. So I would just talk to them nicely, try to keep that balance, right? And let's see if we can't go ahead and get them to sign and agree to that. And that would be a great place to start, is just be open, honest with them and tell them it's a new agreement on a month-to-month with new terms. Make sure you have the new disclosures in there that are required by law. That would be the mandated disclosures regarding bed bugs, lead-based paint. This would be an opportunity for you to upgrade your rental agreement, okay? And make sure you have all those disclosures in place. One of the ways that I approach a tenant is, there's so many new laws protecting you. I need to have a new agreement so that you know what those new rules are and all those new laws so that you're protected. So it's just another way to approach them without them slamming the door in your face, is, hey, new laws happened and I want to make sure you know what they are. So that you're protected. Usually that gets their attention and they're like, oh, you want to protect me? Okay, what are we talking about? So sometimes that opens the door in a friendly manner rather than them slamming it in your face.
Patty,
All is in the approach, you guys. Yes.
On that topic, if it's in the city of LA with rent control, are you still allowed to write up a new lease? Because from my understanding, only the first lease is the only one that can be valid. So
the original agreement controls unless all parties agree. And if they're like similar terms with no rent increases and no late fee increases, and they're like similar terms and both parties agree, then that lease controls.
Got it.
But you can't do a new rental agreement, raise the rent $500, ask for a $2,000 security deposit and a $400 late fee and think that that's going to fly. In LA, that doesn't fly. It's got to be like or similar terms. Hold on, I'm getting another question from Miss David. Can you charge extra for unauthorized persons living there? Write a new lease. How much? San Bernardino. You can in San Bernardino, the option's yours, okay? So non-rent control in San Bernardino, and they have unauthorized people, you can tell them because you have additional occupants, they need to sign an application and be added to the lease contract, and the rent's gonna go up because of that. So it all depends on your approach and how you approach them. You could evict them for having unauthorized occupants. You could add that person into the lease. You could, you have options. So it's up to you what you want to do. But once you start down a path, that's the path you chose. You can't get halfway down the year and try to change it back over. Okay. It doesn't work that way. You can't keep taking their rent and telling them it's okay and then try to evict them 6 months down the road. It's unethical. I saw another message from Jacqueline. Let me see what that is. I have an addendum that says an extra person gets added to $200. Everybody, if you have that addendum, then that's the rules that everybody signed and agreed to. The only place you may see that is giving you trouble is if the property is subject to either statewide or city rent control. You can't raise rents higher than the allotted amount annually. Period. End of report. Doesn't matter if they have unauthorized occupants. In city of Los Angeles, you can actually charge an additional 10% for unauthorized occupants. And that's the city's rule. So, hey, every once in a while we win one, not always, but it just depends on the area and what you're trying to do and what you want to get out of this. Anytime you're adding somebody to the lease or taking more money, make sure you're getting their information. We want to know who's in there. That way, 6 years from now, if you have to evict, you have teeth in that person. Okay. I hope that helped. Anybody have anything else for me? Okay, starting today, I'm back on the road again for 2 weeks. So bear with me for the next 2 weeks. We could be in Las Vegas. We could be in the Sierras, but I'm coming to you live on Wednesdays, wherever I'm at. So we may be at Yosemite National Park. You never know. I'm a little crazy. Ed knows. Sometimes I'm like, hi, live from New York. Now I'm in wherever I'm at. So back on the road for the next 2 weeks, just so that you guys are aware, we're still going to do Wednesdays with Widget. So we still have that. But I'm just telling you, I don't know where I'm coming to you live from yet. It's an adventure.
Coming to you live from somewhere in the
somewhere on the planet. Actually, I will still be in the States. So unless I go to Vegas. So I'll be here for the next 2 weeks. I just don't know where. Fishing season is ending in the Sierras on the 15th. Want to make sure I get my fishing in before the year's over. So hence why I'm headed to the Sierras.
Cool. Well, have a good time.
Teresa, did you have a question? I see that you have your hand up.
Yeah.
If you have a question, you can type. Oh, go ahead, darling.
You may type it in? Okay.
No,
I'll
you
type
can
it.
talk to me. I can see you.
Okay,
Hi.
I'm sorry. I was unprepared. A dumb question. So unauthorized, like person smoking pot and, you know, having, you know, smoking in there is getting me sick. I can smell it. And,
but it's not in your written rules.
there is none.
See the problem? So when you have something that, exactly. I get it, but if it's not in your written rules, it becomes really hard to enforce unless it's law or the city doing it. So
okay.
your city does not have a non-smoking ordinance in multifamily communities, but buckle up, people, it's coming. It's not a matter of if, it's a matter of when. When that happens, then you can evict them for it because it's going to be a city law. It's going to be a statute. But for right now, if it's not in your agreement, you can't do it. You don't have an agreement, so you have to depend on whatever's governing you. City law, state law, federal law, those are the rules they have to follow.
Oh, dang. Oh.
Yes, yes, yes. but you have a nice little loophole with the fact that it's an illegal unit.
Yeah,
But you
Okay.
need to talk to Fernando, Brandy, or Joel in regards to that, especially in LA City.
yeah, it's terrible and, okay. Okay, I
Okay?
let too much time go by. Okay, so because,
Hey.
okay,
Don't worry about it. But again, you hear me talk about what does your lease contract say? What does your lease contract say? Let me say this to you guys, and please hear what I'm trying to tell you, okay? When you have a lease contract and you got it from the apartment association and you don't understand half of those terms in there because they're written in legal language, don't think that you know better and you want to make a separate addendum for all the rules you want. Because 9 times out of 10, your lease contract already says that, even though it's in language we don't understand, and it's written like an umbrella. So it covers all kinds of things, okay? When you come in and you start narrowing down, you can only use this cleaner, you can't use sticky back shelf back paper, you can't put hot items on the countertops. I'm giving you an example. And you make these rules when the tenant leaves and they burned a big hole in the floor because they set a hot pan on the floor because the rules said they couldn't set it on the counter. Now you want to charge them for that hole they burned in the floor, and you can't, because your rules didn't say anything about burning a hole in the floor. So don't think that because you don't understand your rental agreement that you're going to outsmart it. Lots of times you end up standing on your own feet because you took away that umbrella protection and made your little list of rules now what controls. So if you have questions about your rental agreement and what those legal terms are, by all means, contact your legal counsel. Ask me. I'd be more than happy to help point you in the right direction. But when you start making little rules, it takes that umbrella and closes it like this so that you're not protected out like this. So we want to make sure that we're not doing that type of thing. I will be teaching a class probably the end of November called Understanding the Terms of Your Rental Agreement, so that we can go over that legal language you don't understand and I could put it in simple English for you. Okay, that's all I'm trying to do, so that you guys understand the reason it's written that way is it's like an umbrella. It covers all kinds of stuff until you start making little rules on the sides. Then your little rules is all that counts and that big umbrella closes. That's how that works. So we want to be careful we're not closing the umbrella. Fair enough? So something else to think about in all of the mess of everything that we deal with on a daily basis. Anybody else have any questions for me? Nobody? Nothing? We got nothing? We're all caught up? Yay! All right, things I can tell you guys to watch out for. The city of LA has a moratorium. I'm sorry, I misspoke. The county of LA has a moratorium right now. No evictions until the end of November. They're most likely going to extend that. Other things that we can anticipate seeing changes from legislation is AB 3088, which is the new Tenant COVID Protection Act law that hit us all on September 1st. That expires on January 31st when that 25% of the rent is due and 75% balance becomes due the next day. My opinion is all the tenants have to pay all that rent in 2 days. They're going to make some kind of law on the back end to extend that, to cover that, to make payments on that. How can they pay 75% of the rent from March all the way to January in 1 day? They're not. So more than likely, we're going to see an amendment come out for 3088 or something along those lines that messes with that February 1st drop dead date of when all the back rents are due. So just be mindful of that. I'm trying to paint a picture for you. Also, I have heard that Italy and other countries are back on lockdown with COVID round 2. Okay, if they're doing it, maybe we're going to end up in that position as well. Just something to think about. We're going to have to potentially hold rents for even longer than we're already anticipating. So prepare yourself for that. Buckle up, brace for impact. This could be much worse before it gets better. And I'm not trying to be your bubble burster and your dream crusher. I'm trying to put reality in the picture for you guys. We're in a pro-tenant state. They make all the laws for the tenants. That's not going to change. They are the majority, and we as landlords are the minority. Okay, we're a very small group. So politicians make all the laws for the people that have the majority of the vote, which right now is the tenants. So that's why they favor in that direction. I hope everybody voted no on Prop 21. I'm pretty sure we're going to win that one, because even tenants are going no on 21 now that they understand how that's going to work.
I think it was defeated. I got an email from one of the associations saying it was defeated, but I'm not sure.
I thought so too, because somebody said it to me, but I didn't want to say it on here and be like, blah! So just so you guys know, they're trying to put vacancy control on our statewide rent control. In other words, you have somebody living in a house in, and I'm going to give you a great example, San Bernardino, okay? And they haven't raised the rents in 4 years. The tenant moves out. Now you want to bring it up to market value $2,300. You're not going to be able to do it. You can only going to be able to do it 5% plus the CPI. So your $400 rent just went to $412 a month instead of the $2,300 a month that it is. If Prop 21 doesn't pass, we won't have that. So everybody, fingers crossed. Ed's pretty sure that we defeated it. I'm pretty sure we defeated it, but I will not say a word until, I was going to say the fat lady sings, but that's probably not the right analogy. My bad. I am human. But keep fingers crossed. Hopefully we'll defeat that, because we don't need any more challenges in our lives.
I'm just reading I got an email from the California Apartment Association titled Proposition 21 defeated. And it says, once again, the California Apartment Association has helped keep extreme forms of rent control out of the state. Thanks largely to a campaign led by CAA voters in Tuesday's election rejected Proposition 21, a statewide ballot measure that would have invited back the radical rent control policies that proliferated in the 1970s and 80s. As of Wednesday morning, with 99% of precincts partially reporting, 59.8% of the voters had rejected Prop 21, while 40.2% voted to approve the measure.
Awesome. You guys, that's great news for us, okay? And all we can do is keep our fingers crossed and keep trucking forward. It's getting challenging out there, and it's getting a little scary. Remember that if you do a 15-day notice for non-payment of rent and they don't pay or give the declaration within those 15 days, you're required to do a 3-day quit behind it before you file legal. Again, I would say stop chasing the money, because there's too many ways they could just say, I'm affected by COVID. And the reality is, you guys, we've all been affected by COVID. Affected is a very broad term. We're all having to wear masks places. We've all had to spend money to go buy these masks. So could they say that they were affected that way? Absolutely. Are we going to have the time and effort to challenge it? Nope. And the judge isn't going to let us. So as much as I hate to say this, but it's what it is, stop chasing the money. It isn't due yet. Go after cause. Serve that 24-hour notice. When's the last time you went in and inspected the property? What are they doing in there? What preventative maintenance needs to be done? Because when the rent is due and the state does open up, if they have habitability issues, the rent isn't even owed. Just saying, something to think about. So put that in your little chip up there, and remember that you do have other tools to go after. Even though for us as landlords, it's all about the money, the reality is it really isn't all about the money. And right now the money doesn't have any teeth, cause does. So start looking at those causes. Are they not letting me in? Did they change the locks? Did they paint without my permission? Did they put up a video camera system without my permission? Do they have unauthorized occupants? Are they breaking other rules, not maintaining the landscaping, keeping it a filthy mess? And when I say filthy, I'm not talking about living, I'm talking about hoarder status, okay? Everybody has a different yardstick of clean. Ask my kids. They'll tell you. Mom's crazy. Oh, does anybody have anything else? Otherwise, I'm going to end this for today, and I will definitely see you guys next week. We got nothing? All right, you guys have a great week, a great weekend, and I will see you next Wednesday for Wednesdays with Widget. If you need anything in the meantime, feel free to call me at 855-WIDGET-5 because I am not going to be at the law firm at least for the next 2 weeks. Yay, gonna play.
Have
All
fun.
right, you guys, 855-WIDGET-5. Thank you, David. Yes, I'm on a mission. All
Have
right,
fun. Thank you so much, Patty.
all right, thank you, you
Thank
guys.
you.
And then, like I said, if you need anything, hunt me down, okay?
Bye-bye.
Bye.
Well,